All right, good morning, everyone. I'm Judge Breslow, presiding judge in Department 8 of Nevada's 2nd Judicial District. We are proceeding this morning pursuant to Nevada Supreme Court Rule Subpart 9 and various administrative orders of the Nevada Supreme Court and Nevada 2nd Judicial District Court, which allows simultaneous audio-visual transmission of hearings like this using the Zoom webinar platform. For those of you watching, you already know that this hearing is available to be observed through the court's link to the Zoom webinar. I am currently in Washoe County, Nevada. At this time, I ask the court clerk to identify herself and from where she is calling in, and then the court's certified shorthand reporter, Ms. Zinn.
Amanda DeGaynor, Court Clerk, Washoe County, Nevada.
Thank you very much, Ms. Zinn.
Isolde Zinn, Washoe County, Nevada.
Thank you, Ms. Zinn. We are on the record in case number civil 20-00755, filed here in Washoe County. The case name, beginning with the lead plaintiff, Ms. Amethyst Payne and others versus the state of Nevada with relation to the Nevada Department of Employment, Training and Rehabilitation, otherwise known by its acronym D.E.T.R. That's how the court will refer to the defendant respondent in this matter. I ask at this time counsel for plaintiffs to please identify themselves, confirm they can hear the court, and identify what county they are calling in from, starting with Ms. Jones.
Thank you, Your Honor. My name is Leah, L-E-A-H Jones, and I'm calling from Washoe County, Nevada.
Thank you very much. Mr. Thierman.
Mark Thierman, T-H-I-E-R-M-A-N, also from Washoe County, Nevada.
Thank you very much. Counsel for D.E.T.R, if you would please identify yourself, spell your last name slowly and loudly, and indicate, please, to the court who will primarily be arguing on behalf of the state.
Good morning, Your Honor. This is counsel for D.E.T.R. My name is Robert Whitney, last name spelled W-H-I-T-N-E-Y. I have with me Deputy Director.
Mr. Whitney, before you go on, would you please put the camera on so we can see who's joining us on this hearing? All right, thank you. And that should go as well for any named party or any counsel that will be involved in this hearing. If we could please turn the video on as well as just the audio. And for the record, I asked Mr. Guisson to join us just to observe, and his role in all this may or may not become crystallized later. All right, go ahead, Mr. Whitney. Who else is with you, please?
I have with me Deputy Director Dennis Perea, Deputy Director of D.E.T.R, last name spelled P-E-R-E-A.
Thank you.
I also, up north, D.E.T.R also has counsel in this case also. I will be primarily arguing. The counsel up north today is Gregory Ott, last name O-T-T. And with Mr. Ott, I believe is Miss Administrator for Employment Security Division, Kim Ga, last name G-A-A. And also Employment Security Division Counsel, Troy Jordan, last name J-O-R-D-A-N.
All right, thank you.
Thank you.
Mr. Whitney, or is there somebody else as well?
Greg Ott is in the north as well. And then David Schmidt of D.E.T.R as well, Your Honor.
All right, thank you. Mr. Whitney, when you address the court, is there any way for you to get closer to the camera? We're limited in part by the size of the screen and the ability of either to have speaker view or gallery view. And it makes it easier to hear what you're saying and understand what you're saying if you're able to be seen. That helps a little bit. Thank you very much. All right.
Thank you. I'll try, Your Honor.
All right, appreciate it. Mr. Thierman, Ms. Jones, would you like any of the named plaintiffs to be brought in as panelists? And would you like to introduce any of them or all of them, including Ms. Payne, or is that not necessary for the purposes of this hearing?
Not necessary at this time.
All right, thank you very much. The court directed this hearing by signing the writ, ordering the state to appear and show cause, if any it had, why a writ of mandate should not issue. Stating what we all know, the COVID-19 pandemic has caused countless personal, economic, and social suffering. It has left no quarter in Nevada, the Western United States, the Western Hemisphere, and indeed worldwide. The court has personal experience as well, as the court's son is an ER doctor in a level 1 trauma center in a big city. So the challenges that people are facing, the disruption of their lives and livelihood, the court certainly takes judicial notice of, and the challenges that states, municipalities, counties are facing in combating its effects, both on the health, safety, and welfare of its citizens, but more to the point for this hearing, the financial well-being of those entitled to assistance. So I'm sure we'll hear from both sides a recognition of what the court just said, perhaps even your own take or emphasis. But these are things we all already know. The question before the court today really is simply whether the district court here in Washoe County should order the state to do something that it is not now doing, that it ought to be doing as a requirement of law. State law, federal law, or both. Or, as the state argues, should the court decline to exercise such discretion, because as the state has argued in its papers and as the court fully expects, the state will argue that it is complying with its state and federal mandate to fairly process claims and pay people deserving of payment under one or more federal laws. At the end of this hearing, the court will make a decision. The court will either grant the writ, modify and grant the writ, deny the writ, or take it under submission and give it further thought. But you have the court's undivided attention. This case is beyond important, both to the state, to the people who have not received benefits that they believe is owing, and to others who are affected. Usually on an order to show cause, I have the party summoned to respond, be heard first, I'm going to vary from that at this point and hear first from the petitioner plaintiffs. Let's start with what I think is dispensed of rather easily. Mr. Thierman, I'll address you unless you ask me to address Ms. Jones to respond. Why is the venue here in Washoe County for this case? Is venue proper? And why do you believe that this court has jurisdiction to render the relief the plaintiffs have requested? We'll get to why you believe the court should exercise that discretion and enter a writ. But let's talk venue and jurisdiction first. Mr. Thierman.
Yes, Your Honor. Well, venue is two of our plaintiffs, named plaintiffs, reside here, were supposed to receive payment here, applied for the assistance from D.E.T.R here, and I'll pull up the statute, but I believe that gives us venue over the agency under NRS 41. As far as jurisdiction, this court has jurisdiction both under the Constitution and under the NRS to command a state agency in the state to perform a duty that is either inherent in its office or compelled to do by law. Obviously, we argue that the duty is to pay benefits when due. The statement of jurisdiction in our original opening brief, I think, is pretty exhaustive. I would like to add under 42 U.S.C. 1983, you have jurisdiction over the individuals, not for money. There's a limitation on money damages against an individual, and the property that was taken, we allege it was a taking of property without due process, both under the Nevada Constitution and under the federal Constitution, was the entitlement or the payment of this money. And for that, I will cite the California Employment Development case, Department of Development, EDD, versus Java, which specifically says that the right to a fair hearing, a right to continue to have payments made pending that hearing, all derives out of the fact that this entitlement becomes a property right at some point. The point that it becomes a property right, we contend, is the soonest point possible, which would be when the initial application is made and either an initial determination is made that it is acceptable, or that in this case, because there's been no determination for more than 28 days, that it should have been made, and that the four corners of the document indicate that it is in fact a prima facie evidence of a claim for that money. So the property interest under the Constitution is the claim for benefits and continuing claim, and the constitutional and writ jurisdiction is because the state agency, this court has jurisdiction to issue writs over state agencies, and venue being proper because two of the named plaintiffs reside and were working here and were applying here. So that gives this court jurisdiction. It also gives jurisdiction in Carson City by statute. We chose here.
All right, thank you. Mr. Whitney, does the state contest either venue or jurisdiction? Venue because at least two of the plaintiffs reside and work here and apparently have applied for benefits while they were residents of this county, and also with jurisdiction that there's a federally protected right to seek payments in the manner in which the petitioners here have sought, and or for other reasons.
Your Honor, we do not contest the venue or jurisdiction being up in Washoe County. I know there was mention of section 1983 being applicable here. We did contest that as being applicable. We don't think that has any place in the hearing, but with respect to venue and jurisdiction, it was our understanding from reading through the documentation that there were multiple plaintiffs that were residing in Washoe County. So no contention with that, Your Honor.
All right, thank you very much. The court finds that jurisdiction is vested in this court and venue is proper. Mr. Thierman, please proceed make argument, please, as to why the court should grant the writ in the form sought by the petitioners.
Yes, Your Honor. As I started to say, and I think it's pretty clear in the papers, that the entire unemployment compensation system throughout the United States is a federal entitlement or federal policy, and it's under the 1930s Social Security Act, which states that payments must be made when due. And the states are administering it both by the supremacy clause as well as a written agreement that they file or sign. In this case, I believe it was attached to the exhibit, it's Exhibit 3. I don't know if it was to Ms. Ga's declaration or freestanding Exhibit 3 to the initial response by the state, but that was the, I believe, March 28th, she signed it. And the state of Nevada is basically deputized to implement the distribution of funds provided by the federal government. In this case, not only is the funds provided by the federal government, but so are the cost of administration. And there are some other perks and obligations in there. But the basic concept behind this whole system is that during the Great Depression, we needed to help people as well as to stimulate the economy. The federal government did it through the states, and that is the way it has continued to be administered throughout the nation. And it's a cooperative agreement so that there's permission and an agreement to do it according to federal guidelines. And I will add that the federal guidelines, we have a very different take as to interpretation, but the federal guidelines cannot be in dispute. They're issued, published for all to see. Our contention is that the state has not fulfilled its duty to pay payments or to make contributions to unemployment compensation when due. I think there is a distinct different philosophical view of the role of D.E.T.R in this process. D.E.T.R, at least as far as I can tell, has taken the position as somehow of a gatekeeper, a police person, as opposed to being an enabler. And that is simply giving D.E.T.R the wrong emphasis on what its job is. Its job is to distribute these funds. The gatekeeping or fraud aspect of it, which D.E.T.R likes to talk about, is a minor component. It is specifically talked about in the regulations and in the C.A.R.E.S Act. This comes out of the C.A.R.E.S Act, which is a federal statute because of the pandemic that was passed. It is unique, but it is modeled after the disaster unemployment assistance program from the 1970s. And in fact, the regulation specifically, the C.A.R.E.S Act specifically substitutes pretty much as an administrative shorthand, the terms P.U.A, pandemic unemployment assistance, for D.U.A, which is disaster unemployment assistance. So it's not like this is totally new territory. And it has been, the D.U.A process has been used successfully, mostly in hurricanes and other national disasters, not so much in Nevada, but in the South and along the Gulf Coast. But it's been around for a while. And the purpose, like as I said, is to specifically provide for compensation for both to ease the suffering of individuals. And by the way, my son is also an ER doc in Baltimore. But to ease the, because I hear about these cases from him all the time, the suffering of individuals and their families who are unable to work through no fault of their own, as well as to stimulate the economy, put money in the hands of people who will spend it, and to keep the rest of the economy that is consumer driven afloat.
Hold that thought. Let me ask one question. You mentioned a moment ago that the petitioners believe that the state is approaching this somewhat as a gatekeeper.
Yes.
Like there's a big bag of gold behind a wall, and their job, as I read the plaintiff, and the theory or the theme seemed to be that the plaintiff, the petitioners believed that D.E.T.R had it wrong, that D.E.T.R was attempting to find a way to prevent payments unless and until such and such. And the petitioners were of the mind that there should be essentially a presumption as to the validity of an application for benefits. And I want to make sure that I understand the theme here, because when I read the state's opposition, I didn't get the sense that it was going out of its way not to pay benefits. It appeared to the court that it was attempting to pay benefits consistent with its charge, with its mandate to pay claims that were viable, that were justified, that otherwise triggered a benefit amount of payments pursuant to the C.A.R.E.S Act or the agreements reached. Why do you think that why do you think it's other than that?
As you know, the Supreme Court has
Okay, why don't you give me the statute? I'm not putting up with any of your crap here today.
The court will take this matter under submission.
This is the time set for your hearing on custody.
Don't unpack. That's not what today's hearing's for.
The likely result of that is you will be remanded into custody.
Okay, and are you opposing that?
Okay, well, for several reasons. One, the charge in the C.A.R.E.S Act and in the interpretive bulletins by the Department of Labor is to, and I'll quote it, states are required to take reasonable and customary precautions to deter and detect fraud, such as random audits of a sample of claims, separate self-certifications and warnings, basically a separate document with a Juror Act, and a warning telling them that they're submitting to this document on the penalty of perjury, and they can be prosecuted for that if it's false. And and repayment of excess. Instead, and the only outside check, unless there's a flag written somewhere in that file, the only outside check to an outside source is to make sure that they do not have sufficient credits under the traditional UI programs to claim that there. And if they do, I would say further that then they should be paid from the UI program. And we're really not talking about a difference in amount. We're talking about a difference in accounting. Instead, what the state has been doing is been subjecting all of these claims to a rigorous reinvestigation of, under the UI program, of prior standing, of prior disabilities. When I say disabilities, disqualifications. For example, if you quit your job or your next to last job to become a gig worker and you do not file a claim, you have an open file in the UI system for why you quit. What D.E.T.R has been doing has been basically resurrecting that disqualification, because it says you cannot get benefits as long as you've got a quit on your record that hasn't been cured, without even looking to see whether it's cured or not, and just say, hold on, I can't do anything. You have a pending claim in UI, or you have a valid claim under the UI system. Many of my clients, and I get over 200, 300 emails a day. I can't process them all, have claimed, and then I believe them, that they have uploaded determinations from the UI, from the unemployment insurance, which is also administered by D.E.T.R, saying they are not eligible for one reason or another, that their credits have expired because it's been too long, whatever the reason. They upload this to the P.U.A program as on the gig website, which wasn't established until May 16th, but they upload it, and they're told, well, you still have something going on UI. We can't do anything. We can't pay you PUI, and we can't pay you UI, so you get nothing. On top of that.
Well, hold on. You know, normally I let one side go, then I hear the other, then I let the response. But sometimes I want to bottom this out before we move past it. Mr. Whitney, what you just heard Mr. Thierman say that the department is doing, is that true? And if so, do you believe that the state is justified in approaching it that way, or do you think there's any merit in Mr. Thierman's argument that is impermissibly delaying the payment of otherwise due funds?
Your Honor, it's my understanding that D.E.T.R they're making eligibility determinations for both P.U.A and FPUC. they're making these determinations pursuant to the guidance, the U-polls that are sent out by the Department of Labor. But going by the U-polls, they're making the determinations that they need to be making. First, determining if a person, for example, for the P.U.A, is the person eligible? Is the person eligible for unemployment insurance? Is the person eligible for extended benefits? Is the person eligible for the pandemic emergency unemployment compensation? Because if they are, then that person, and also there also needs to be a COVID-19 related reason, because under the federal guidelines, if the person is determined ineligible for those reasons, they're not going to be getting P.U.A. It's the C.A.R.E.S Act that the determinations under it that D.E.T.R is actually focusing on. With respect to resurrecting a prior disqualification, and speaking with D.E.T.R's experts on that, and they're present today in Carson City. My understanding that those types of issues they were not looking at.
You can't both be right. Either Mr. Thierman's right that that's how the state is approaching it, and it's causing what the petitioner argues is interminable delay, or the state is not approaching it that way. I mean, I really, for purposes of this hearing, would like to know the answer to that question, because it seems to me that's one area that, according to the petitioner, hundreds of people are sort of in this limbo, trying to explain their way out, and their explanations have either been thus far unsuccessful or they've had no adjudication on that. Mr. Thierman, did I state that correctly, or
exactly?
Did the court
And I mean, if you're going to shape an order, eliminating anything more than that superficial "do you have hours in the bank for 18 months" requirement, which is that is what the C.A.R.E.S Act requires, and only that would be would probably end most of this, 2/3 of it at least, because my people are telling me that they are being told that they cannot get P.U.A because they have a U.I. determination or a U.I. claim or U.I. eligibility. If you have U.I. eligibility, not that they're getting paid U.I., because I agree we shouldn't get paid twice, but if you have U.I. eligibility, then start paying them under the U.I. program. They're administered by the same people and the amounts are the same. It doesn't really matter to the recipient which accounting box is checked. And I want to add kind of a digression. We've gone around and around this thing. It is true that you have to have an underlying P.U.A. or U.I. or some of the other extended benefits, some of the other more esoteric programs in order to get this FPUC, Federal Pandemic Unemployment Assistance.
Right, that's the extra $600 a week, right?
Right, and if you make it all the way, you get $600 a week for 13 weeks. We are getting a lot, and I think it's in the declarations, of people telling us that they can't get one because they're possibly eligible, or D.E.T.R says they're eligible for the other, but in either case, they get none of the FPUC. That's illogical. They're going to get one. They're entitled to one. You only need one to get the FPUC. And that $600 a week is life-saving to so many of these people. And there's no reason for delay. You know, Pennsylvania doesn't have this delay. Other states don't have this delay. I think we brought up in the reply brief that this fails to meet even the minimum standards under the DOL's acceptable performance. They I think require 87% paid within 2 weeks. We on the gig worker class, we have a third not being paid in 3 months, and it looks like, and I'm not so sure why they eliminated another $50,000 from the mix. Whether these are people for some reason they say just don't belong in the system, whether they're up in adjudication or something, but they're just kind of lost there. And they also don't seem to fit, and they're not getting the FPUC payments because they have one or another, but we know it's one program underneath them being blocked or contested by the existence of another. So
right,
the catch-22.
All right, let me make sure the court understands this, because what you said that really resonated with the court is, you know, and we're not doing strict math here, but you've estimated that about 2/3 of the people that you believe have been unduly delayed in receiving benefits are part of this bubble of people that you maintain, Mr. Thierman. The state is identifying as having a balance or an open claim or otherwise an unresolved issue with prior unemployment insurance matters. And because of that, they're not getting what the C.A.R.E.S Act might otherwise provide. But at the same time, you allege that they're not getting any benefits under the old version, the existing version of the state unemployment insurance. Do I have that right?
Exactly. In other words,
right, so let me ask Mr. Whitney, if do you think factually that's inaccurate, or it might be accurate, but the state's working through these, or how would you respond to that concern expressed? I mean, I know you started your answer and I sort of cut you off, but go ahead, and I want to make sure I understand fully D.E.T.R's position on this issue.
Your Honor, I don't believe that 2/3 of the people are delayed because of that bubble. I don't think that that's actually probably a correct number.
Well, is there anyone, and I'm not going to limit hearing just from you if there are other people on this call that you believe are possessed with additional information or facts that can inform the court on this very important matter. You can direct me to them and I'll hear from them. But I'd like to know the state's view of where the inaccuracies of what Mr. Thierman just said exist.
A couple of things, Your Honor, just really briefly. Other than that number of people, the 2/3 number, we think that he's actually looking at just in general, the application of how P.U.A works actually incorrectly. D.E.T.R is going to make D.E.T.R is making its determination of P.U.A benefits and those FPUC benefits based on the federal guidance, based on the C.A.R.E.S Act and how the federal guidelines set that out. It's not focusing on the NRSs. He had also, just really quickly, also mentioned the acceptable performance levels. He mentioned the 87%. That was, Mr. Thierman's actually getting that from 20 CFR 640.4 and 640.5. He cited that in his reply to our opposition. Your Honor, that when you look at read those two statutes, it's referring to 640.5, really the validity of the state law. I'm sorry, 640.4 is really talking about the validity of the state law. I'd be talking about the validity of the NRS is dealing with payment of the unemployment benefits. 640.5 really deals with the time lapse between first-time payments, time lapse between the determination and first-time payments for the unemployment benefits. But they're actually, again, they're dealing with the validity of the state law. They're dealing with actually unemployment benefits and the administration of unemployment benefits. What we're looking at here again is something quite different. We're looking at P.U.A and FPUC again. They're not state laws. It's not dealing with the administration of state law. It's dealing with the administration of a federal act, the C.A.R.E.S Act. So there's, I guess, a difference there about the applicable law. As far as the what's really causing the delay, perhaps I understand Mr. David Schmidt is up north, and he or Administrator Goff probably have the most information on Mr. Attorney Thierman's specific allegation about.
Well, let me. I know Mr. Thierman. Now, who put that up? Who put the screen share up?
Or that was the Chief Economist Dave Schmidt who put that up, and he's coming to give some additional detail on that. We can take it down if you prefer.
Well, please take it down unless he identifies himself, ask the court's permission to put up some information, and we do it a little bit more formal.
Apologies, Your Honor.
That's
but
all right.
He's coming to the table now to identify himself.
All right, no problem. And do me a favor, because you're far away from the camera. We can't read your lips if you're wearing masks, and I appreciate that you're being safe. And also, I need to make sure the court's certified shorthand reporter, Ms. Zinn, can hear you. So please speak clearly and loudly and slowly, and go right ahead, sir.
Thank you, Your Honor. My name is David Schmidt, SCHMIDT. I'm the Chief Economist for D.E.T.R. And what I was trying to share, I didn't realize it would automatically go up. My apologies for that.
That's all right.
Is a about 1 week old pull from the database. We just yesterday got access to do our own custom reports from the P.U.A system. And it shows for approximately 247,000 P.U.A claims that have been filed, what the status is on those claims, and where there are non-payments, what the primary cause of those non-payments are.
Okay, hold that thought. Mr. Thierman, any reason why the petitioners would object to Mr. Schmidt showing us a schematic of what he has identified based on what you've just heard?
Subject to a polite cross, no objection.
Thank you. Mr. Schmidt, you may proceed and educate the court as to what your findings suggest.
Thank you, Your Honor. I will go and, all right, we'll share the screen and I will walk through it again.
Thank you.
Share screen, Excel, and share. So what this is a combination of data from the various tables in the P.U.A. database to look at how many P.U.A. initial claims have been taken and what categories do they fall into. This is a hierarchical approach, and so if someone falls in category A, they will not also show up in category B and so on. So you can see that as of a week ago, when the database was last refreshed, we had paid out on 107,000 P.U.A. claims. Another 17,000 claims after that had failed an identity verification.
What does that what does that mean? What does that mean?
They did not have a valid social security number, which is one of the key inputs to the system. Another 45,000 people had UI wages that were reported at the time that they applied for P.U.A. benefits.
Now, does that mean they are receiving benefits, or they are eligible to receive them, or there's an open claim, or what does that mean?
That would mean that they are potentially eligible for unemployment insurance. And under the provisions of UI Program Letter 1620, if there is questionable eligibility, the UI eligibility needs to first be resolved in the unemployment insurance system.
Okay, well, you've hit on an issue of contention here because, as the court understands the petitioner's argument, it's taking too long. The petitioners are getting inconsistent directive, and the delay is causing and will continue to cause harm unless the court does something to break through the logjam. Mr. Schmidt, what do you think of that?
I certainly understand the frustration that causes. This isn't necessarily the only reason that these people are not being paid, but it is a important reason.
I see that. And before you move on, Mr. Thierman, are these 45,328 part of the bucket that you identified? Possibly 2/3 of those that are aggrieved, as alleged in the petition, are encompassed in that number?
And the numbers match pretty close to what the group of people who have not been paid. Whether that 45 includes all P.U.I. out of 100,000, I think that's what he's trying to say. I think that's 45,000 is out of 100,000. So I don't know how it distributes between gig workers and non-gig workers, but 45,000 people who have not received UI wages and who are not received UI payments and who have not received P.U.A. payments. I mean, that's devastating. That's
all right, hold that thought. Mr. Schmidt, just so the court understands. So under C, the apparent UI wages, these are people that have not been paid any claim either through the UI or any of the pandemic relief funds that have been made available. Is that fair?
No, Your Honor,
right.
Because people could apply in both systems. This is not a mutually exclusive program. And so this data does not say that these people have not been paid or will not be paid in the unemployment insurance program. It merely says that they have wages that they reported within that program at the time that they applied for P.U.A.
All right, but again, as the court understands, is that many of the petitioners have alleged that this is tripping them up from having their claim promptly processed and then benefits received. So, all right, let's continue. We'll catch up. Number of weeks filed, or no?
So, Your Honor, number D there is people who have filed an initial claim for P.U.A. but have not completed any weekly filings that are the basis for making payment. So they have not completed the process that would allow them to be paid.
Okay, hold that thought. Mr. Thierman, what do you make of that?
I have no reason to dispute it or deny it. I don't know if these people have been told not to file claims or if these people don't know to file claims, but if they don't keep up their weekly looking for work, although one would argue a gig worker really doesn't have to do that under the statute. they don't get paid, but they can go in at any time and do that. That's on them. I agree.
All right, fair enough. I mean, Mr. Schmidt, it's a bit curious to the court that this many people would file an initial application for benefits, but then not keep it current on a weekly basis. Are you attributing that to some attrition? They found full-time work. They've changed their mind. They realized they weren't otherwise qualified for benefits, or what do you make of that? It seems like a big number to the court.
Your Honor, there's multiple possible reasons. I would say this is similar with what we see in the unemployment insurance program as well. So it's not uncommon for people to not file. One cause that I have heard but do not have direct experience with is that where there are automated systems that fail to make it through the claim filing, are you a human sort of verifications, that it will block them from being able to complete the weekly claim process. And so based on the numbers that we report on the unemployment insurance program, out of a total of about 250 to 300,000 weekly claims, we typically see 30 to 50,000 pending weekly claims where the weekly claim is not finished.
All right, so this is not
about a 10%.
Fair enough. This is not in and of itself remarkable then, is that fair?
Yes, Your Honor.
All right, thank you. And then what's letter E stand for?
E, out of country, is one of our verification checks where someone is filing for P.U.A. benefits from outside of the United States. Because P.U.A. is contingent on someone being able and available to work in the state of Nevada, except for the fact that they're out of work due to COVID-19, someone filing for benefits from outside the country is suspicious and needs verification.
All right, Mr. Thierman, I'm assuming.
No objection to that.
Yeah, no issue there. All right, what's F stand for, please?
F is a verification check that we have based on the experience that our vendors had with other states, checking the IP address where someone is filing for benefits from.
To make sure there's no, duplicity, to make sure they're in Nevada, what exactly are you looking for there?
In Nevada and don't have out-of-state wages, which would...
that they're in Nevada and don't have out-of-state wages. Or out-of-state location, rather.
Okay, but if you identify that as an issue, the person sees that and they can clarify, correct, or amend, I assume. Is that fair?
No, they give no notice, Your Honor. That's one of the problems.
All right, well, let's, Mr. Thierman, Mr. Schmidt, or Mr. Whitney, or Mr. Schmidt, your colleague there, how do you respond to what Mr. Thierman says is a bone of contention here?
Your Honor, this is Troy Jordan. I would disagree with that contention, because what that does is it puts a flag on it, and they have the ability to get rid of that flag by giving us the information or us doing the research. So for him saying they get no notice and they get nothing is just simply untrue.
Okay, well, we'll deem that something that there's a dispute factually about. What about G, please, Mr. Schmidt?
Item G is a temporary hold that we're putting on claims beginning around June 22nd. We saw a very significant jump in applications for the P.U.A. program, which in part we believe is due to the publicity around the potential for removing controls on making P.U.A. payments. And so because of the very unusual timing of this spike, coming more than a month after the system launched and became available, to have a flood of new claims coming in that is comparable to the flood that came in when the system first went live, caused concern. And so this is a hold for reviewing those claims to work through that process.
Boy, that's pretty subjective. Mr. Thierman, what's the petitioner's response on that?
It's prejudging the individual by what the group may or may not be doing. I mean, I would think that most people who saw it in the papers or read about it said, gee, I have a chance of getting paid here. I didn't know that because everyone tells me you can't get any money out of them.
Well, here's the thing. Here, let me analogize to this. You know, I mean, there are fraud alerts on our credit cards. If you have some unusual trading, they'll stop a potential transaction and they'll make you contact them to make sure that you legitimately attempted to do business that way. This is a bit of a tripwire, it appears to the court by the state, because they've noticed an aberration. But you know, it's just such a unique circumstance and a unique economic calamity that the state is facing here. The question then before the court is, how do we work? How do we collaboratively work through, or the court order a different approach than that which D.E.T.R is taking because of its concerns that there's something untoward with this amount of claims in that short period of time. So, Mr. Schmidt, those are just the court's preliminary thoughts, but anything else to add on G before we move down to H?
Your Honor, I would just reiterate that this is because of the timing, because of the activity, and because of some of the other details, that this is a potential indication of fraud in the system.
Well,
all right, I'm trying to digest that, but let's move on before we go back to G, if we do this morning. Other outstanding issues. Is that sort of a catch-all for other things that are not captured by some of these other ones?
Your Honor, H is issues where there's a number of potential issues on a claim. For example, if someone indicates that they're not unemployed due to COVID-19, or a number of other small issues, it's not the major fraud indicators, it's other potential eligibility issues to see if someone's application conforms with the requirements of the C.A.R.E.S Act to receive P.U.A.
Okay, let me ask you this. With that, how is the D.E.T.R handling the people who drive, you know, with their own vehicle for a living, like an Uber or a Lyft driver? Because, and then I'd like to know what the state, if you've heard how other states are handling that. Because say somebody was a part-time Lyft driver working 25 hours a week, and then she decided to abide the governor's stay-at-home order, even though it didn't directly apply to her. And now she's back working up to 10 hours because all her business has ended because she works in Clark County and nobody is socializing. I mean, how's the state handling that person? Who can answer that? Mr. Schmidt or one of your colleagues, please?
Your Honor, Mr. Schmidt again. It depends on the circumstances of the case. For example, someone who drives for Uber but also worked in the unemployment insurance program would be handled one way. Someone who drives for Uber full-time would be handled another way. Someone who drives for Uber and has had a reduction in their earnings but hasn't been forced to suspend operations versus someone who completely stopped driving. All of these people would be handled in different ways. If someone reported at the time that they filed that they have not stopped working due to COVID-19, have not suspended their operations, have continued to operate, and are not unemployed for some other COVID-19 reason, I believe that this would apply a question mark based on that detail in their application to their claim, pending review and verification of whether or not they are unemployed due to COVID-19.
All right, hold that thought. Hold that thought, because see that's problematic to the court. I mean, essentially, I guess this is too strong of a word, but I'm going to use it anyway. You're penalizing those that have agreed to try to work 10 to 15 hours because they cannot truthfully say that they have completely ceased working. And so even if it would be to their financial benefit to completely cease working, you know, it reminds me of during the mortgage crisis, where when people apparently reached out for help with their mortgage provider and were told, well, I can't help you while you're paying your mortgage, but once you stop, then you go in a group of people that we can help. And as counterintuitive as that was the world we lived in. What I heard you say, Mr. Schmidt, and I'm not going to for a moment suggest that I will ever know as much as you and your colleagues will forget about this on a regular basis. I'm trying to be a quick study here. but it just seems to me that that is an issue rife with some potential challenges when somebody who completely stops is ahead of the line than somebody who tries to, eke out as much as they can. I don't know, Mr. Thierman, what do you think about that?
I think that the guidance actually by the Department of Labor answers your question exactly, because unlike a traditional worker, a gig worker, it says an individual, and this is the 1620 of the Secretary of Labor's unemployment program guide, or whatever it's called, page I or 11. An individual must certify that he or she is unemployed, partially unemployed, or unable or unavailable to work. This is the partially unemployed. And then it goes on, like D.U.A, an individual filing for P.U.A does not need to provide proof of employment or self-employment to qualify, nor does P.U.A take into account an individual's principal source of income as part of the self-certification. So you can be as rich as you want. If you lose the ability, let's say, to take people to and from the airport because no one's flying, that's a part of your operation that is now shut down. You're entitled to at least that $600 and some pro rata share based upon how much you are earning the rest of your driving of P.U.A. They are not doing that.
All right, Mr. Schmidt, do you know how other states, have you looked to any of our sister states or other states similarly sized to the amount of Nevada residents, how they're handling the rideshare workers with respect to paying out claims?
Your Honor, I don't have that specific information because I'm coming from the reporting and statistics side.
Okay. All right. Fair enough.
Your Honor, at page I-6, it talks about ride sharing services specifically and about people who are not, they don't lose their place of employment because the ride share service is the car, yet the customers are gone. And they say that is enough to a partial shutdown. And they're not doing that. They're not giving them credit for that partial shutdown.
All right. So, but there's no line item for rideshare drivers. There's a line item for other outstanding issues, which Mr. Schmidt candidly indicated to the court would probably grab, some of those people, maybe a lot. I don't know. But all right. And then finally, number 11, line 11, Mr. Schmidt, letter I. What's no detail, please?
Your Honor, may I go back to the page I-6 for a moment?
Yes, of course.
Thank you. I just want to point out that the text of the UPL says that someone may qualify for benefits if he or she is unemployed, partially unemployed, or unable or unavailable to work due to COVID-19 because the public health emergency has severely limited his or her ability to continue performing his or her customary work activities and has thereby forced the individual to suspend such activities.
Okay, Mr. Schmidt, hold on a moment. I want to remind everyone that there is a court reporter who has to hear you and take this down as accurately as she can. So a little bit slower, a little more loudly, and everyone, and I'm talking to you, Mr. Thierman, look into the camera when you speak, if you can, please. Go ahead, Mr. Schmidt. So based on what you just said, what should the court take away from that?
I think the important thing in this is that the text of the program letter says that the individual has been forced to suspend such activities. And that we are in a situation where not everyone who has been impacted in some way by the COVID-19 shutdown is necessarily eligible for benefits on that regard, and that we're trying to apply the text of the guidance that we have.
Okay, but again, we have to follow the law always, but apply that with a little bit of good old common sense. To suspend operations mean you never take anybody anywhere if you're a Lyft driver? I mean, are you penalized if you get in the car and do one job for $20 to McCarran International Airport or to, we have to make some sense of this here. And it just seems again, it's a bone of contention here on how this is being construed. Mr. Thierman?
Yes, Your Honor. I believe one of our named plaintiffs, Mr. Darnish, I believe, is an Uber or Lyft driver who, you know, to feed his family, he lost the tourist trade. He started doing local pickup and delivery and made considerably less. The key to it is the Secretary of Labor has the power to add categories of disqualifications or qualifications, and there's a double K in the statute where the Secretary of Labor says that the individual meets any additional criteria established by the Secretary, and one of those additional criteria is that you lose business, or you lose customers, or you shut down a portion of your operation because of the COVID. It's a causation, and we cannot scientifically measure cause and effect. We have to make some broad assumptions, but it's common sense that if there are no tourists in Vegas, there's nobody to drive anywhere. And yes, that's where we're at.
All right,
and I understand. The language allows that to be compensated.
Got it. Mr. Whitney, did you want to address the court on that issue, or?
Just really quickly, Your Honor. I don't want to really interrupt the flow of what Mr. Schmidt is saying, but the state did address on 16 and 28 some of these contentions Mr. Thierman is making. And we did want to point out that the guidance itself, as Mr. Schmidt said, they do use the word. They don't use the word slow down, decline. They use the word suspend in its I-6 Section K in the guidance, the DOL guidance. It came from UPL 1620. Also,
well, hold on. It doesn't. I mean, okay. You know, you get on an airplane and the announcer says, the flight attendant says, "Welcome on board. We have a full flight today." Now, what does that mean? Does that mean a completely full, 100%? Does it mean a substantially full? What does it mean? So a suspension, does it mean a complete suspension? Does it mean materially suspended? Does it mean, you know, substantially affect your health, safety, welfare, and ability to provide for your family suspension? That's really where the rubber meets the road here. No pun intended, since we're talking about rideshare. But that's I understand where the state's coming from. That's the way you construe it. You're reading it literally. Suspension means you're suspended. You're out. You're done. The question is whether the court should construe that in light of what the court's being asked to do by this writ application to mean that it materially suspend. But I interrupted you. Please proceed, Mr. Rennie. What else were you going to say?
I'm sorry, Your Honor. The only other thing, just a couple things. The court could have, they're very clear in their language. They do say suspend. They could have used some other word other than suspend had they wanted to do so. They also use, in the UPL, they use a specific example, again, of the driver, a ride-sharing driver that has a ride-sharing service, doesn't have a place of employment. Under the additional criterion, the driver might still qualify for P.U.A benefits if he or she is forced to suspend operations as a direct result of COVID-19 public emergency. So again, they use the word suspend in their guidance twice instead of some other language.
But again, I don't mean to split hairs. You stated correctly and accurately, and those that wrote the law or gave the guidance did the best they could under exigent circumstances to get this law passed and the funds to the states to administer as quickly as possible. But really, among those of us on this call, does that make enough sense for the court to deem that what D.E.T.R is doing in compliance? Because again, we're directing people to stop working completely. If you want this court to view suspend to mean that, so that they stop, just so they stop making their mortgage payments so they can get mortgage relief. That's to me an incongruent result. And so I'm still turning that over in my head. Let me ask Mr. Schmidt to go to the no detail item as well. And then we're going to backtrack on issues and further discussion. Please, Mr. Schmidt.
Thank you, Your Honor. The last item in this chart is the catch-all category that you referred to earlier. This is people who don't fall into one of the categories above and who have not been paid. One example that I've seen in this category is someone who, in every week that they filed for benefits, reported that they still had earnings that were above their weekly benefit amount. This may tie into the previous conversation in that if someone has earnings that are in excess of their weekly benefit amount, both in the P.U.A. program as well as in the regular unemployment program, they are considered employed and not eligible for payment. And so someone who has reported earnings, who has not hit any fraud checks, who has not fallen into one of these other categories, if they have earnings every week in which they filed for benefits in excess of that weekly benefit amount, then that person would not qualify for benefits. So it would be possible for someone who was earning, let's say, $1,200 a week. If they had their earnings cut in half to $600 a week, they've clearly been economically impacted, but the maximum weekly benefit under both UI and P.U.A. is $469. And so if they were earning $600, even though they lost half their income, because their earnings are still in excess of their weekly benefit amount, they would not be paid. And so anyone in this category, this would only capture people who have not been paid for any week in their claim. If someone has been paid for a week, they would be up in category A. So this is the catch-all that comes about because I just started digging into this data yesterday.
And these numbers are accurate, I believe you said, as of about a week ago. Is that fair?
Yes, Your Honor. So
doing the math just in my head quickly while we're talking, claims paid number of 107 and everything else B through I are about 120 or 130,000. So is it a fair takeaway that something less than half of the claims submitted have been validated and paid?
Yes.
Yes, Your Honor. And the total, I believe, is about 247,000. So that would be about 140,000 in categories B through I.
Okay. Again, any sense of how other states' ratios compare to what Nevada is seeing? And I fully recognize that the time and effort of D.E.T.R, I'm assuming, is being used to process claims and work through this and not reach out and get information from colleague states, neighbor states. But still, you have a sense of how Nevada compares with these percentages roughly to any other state?
Your Honor, not these percentages precisely, but we do have another thing that went out with our weekly press release last Friday that shows a table of total P.U.A. that's been paid through June 30th. And compares that to the Census Bureau's estimates of self-employment in every state, which may give a way to look at comparisons among the different states in the P.U.A. program. If you would like,
is that another slide you can show the court, or do you just want to tell me what that said?
I can do either, Your Honor.
Well, go ahead and put it up on the split screen if you have that handy, please.
Okay, it'll be just a moment.
Sure. Incidentally, this is not meant to be an endurance contest. If anyone needs a comfort break, raise your hand. We'll take 5 minutes, leg stretch, and come back to it. All right, and that includes the court staff. Mr. Schmidt, please proceed.
Thank you, Your Honor. So this data comes from the U.S. Department of Treasury and U.S. Census Bureau. It looks at the total amount that has been drawn by each state to make payments for the regular UI, P.U.A, and PEUC programs. The FPUC dollars are not included in that data, and so I don't have that available here. In the second column in P.U.A, you can see the total amount of P.U.A dollars that have been paid out.
Well, that was from the last slide, correct?
It should line up pretty closely because this data comes from the U.S. Treasury, and because of the difference of when a payment is registered in the P.U.A system and when the money is drawn from the Treasury to pay for those benefits, there may be some slight differences, but both were in the $300 million range.
Right, and again, the P.U.A stands for the Pandemic Unemployment Assistance Program. Is that fair?
Yes, Your Honor.
All right, please proceed.
In the sixth column over, you have self-employment. This is an estimate from the U.S. Census Bureau based on the American Community Survey of total self-employment in each of the states. The final column is a division of the dollars that have been paid out through P.U.A and the total amount of self-employment in each state. And this paper is sorted from largest to smallest on that column. Nevada, as of June 30th, had the seventh highest amount paid out here. So at least relative to the total number of estimated self-employed workers in the state, Nevada has paid out a lot more P.U.A than a number of other states.
Well, hold on. Let me make sure I understand that. Tell me again where Nevada stands and which column I should be looking at, please.
The far right column on this page is the P.U.A paid per self-employed worker. That divides, as of June 30th, the total dollars that have been drawn from the Treasury to pay for P.U.A by the estimate from 2018 of the total number of self-employed workers in the state, which is the most recent data that the census has available.
So again, we've paid out, when I say we, the state has paid out for P.U.A $344 million, almost $345 million for the estimate from 2 years ago of 82,000 self-employed, which comes out to $4,200 per person, right?
Yes, Your Honor.
Okay, I mean, that's a good list to be high up on, I guess, for purposes of this hearing. But what's the court's takeaway? Because Mr. Thierman is going to say, but Judge, the nature of our economy is such that we have more self-employed workers than most places that are, a lot of gaming tourism based and for other reasons, location, as well as, the number is large per person, but that doesn't justify the failure to pay other benefits that are owed. I mean, I just trying to.
I could add, Your Honor, that the Nevada's paying half of what Massachusetts is paying for the same people. I mean, that's not good.
Yeah, I mean, it's sort of a mixed bit of data here for the court, but
if I may, Your Honor.
Yes, of course.
I think there's a few different takeaways from this chart that I would bring to your attention. One is as we look at the total number of P.U.A applications, the fact that we have 247,000 P.U.A applications against a base of 82,000 estimated self-employed workers is a big and a big discrepancy. I don't think 82,000 is necessarily all there are. This is just a publicly available data source, and it's a notoriously hard concept to estimate. But heading into this, our estimates of the total number of self-employed workers were maybe about 150,000. So that would even be roughly double this number, but still falls far short of the 240,000 claims that have come in. And so one takeaway is, what is the population that may be needing to legitimately receive benefits, and how does our payment activity compare to that? Another one is Nevada was definitely hit hard by the the shutdown and the industries that were impacted, that probably helps support Nevada's position on this list because we may have had more of those self-employed workers potentially affected. So I think you see the impact to Nevada here. I think you see an estimate of who all should be paying if every single self-employed person in the state was completely unemployed due to COVID-19, as well as a relative ranking among the states of how are other states doing compared to that base in getting those P.U.A. dollars out the door.
Okay, well, Mr. Thierman, Mr. Schmidt makes a pretty strong argument that if we're looking at an estimate, admittedly, part art, part science, of 82,115 self-employed workers as of 2018, and realizing the world has changed a little bit in these 2 years on how people do business and support themselves. But if we're over 230 or 40,000 applicants, there does seem to be a bit of a disconnect, even if we give a wide berth to the increase of self-employed in Nevada in the last 2 years. I mean, wouldn't you agree there's something seems to be a little bit amiss?
Well, Your Honor, yeah, but we're comparing apples and oranges. We have an estimate number of self-employed people. We don't know how good it is. And we have a number of people who have applied, which again, we have that number, and we don't have when they got paid. A lot of people are getting paid the last 2 weeks, probably because of the pressure of this lawsuit, are getting $10,000, $8,000 checks. We just got a declaration from Ms. C.A.R.E. as a result of this lawsuit. She went back and looked and agreed that she was doing things wrong. I don't know how many people that affects. I still say that it's not good enough, but to me, the number that most is concerning is the 8,000 for Massachusetts and the 7,400 for Minnesota and Pennsylvania 6,000. Without the timing, we don't have the timing on this, because if these people were being paid within 2 weeks of application and their websites were up May 1 or whatever their websites were up, I mean, these people are doing far, far better than we are. And we just don't know. The graph doesn't tell you.
Your Honor, may I just ask Mr. Schmidt a question? So that 82,000.
No, do me a favor, ask it through the court, please.
Oh, yeah.
And by the way, Mr. Thierman, I think MI is Michigan, but now you've continued.
Sorry.
That's all right. Go ahead, Ms. Jones.
So what's interesting to me is P.U.A. doesn't mean just gig workers. P.U.A. is provided to self-employed, those seeking part-time employment, or otherwise would not have qualified for regular UC or extended benefits under state or federal law, or the PEUC. The coverage also includes individuals who have exhausted all rights to UC or EB under state or federal law. So for instance, if they're still unemployed due to COVID and they were unemployed prior, but they, from what I understand, if they've exhausted their regular UI benefits, that would be included in that P.U.A. number. So I think I agree with Mr. Thierman in that we're comparing apples to oranges here. Just because the 82,000 people are self-employed doesn't mean all of the 345,000 P.U.A. benefits were to self-employed people.
Okay, hold that thought. Mr. Schmidt, what do you make of that?
Thank you, Your Honor. Currently, it's important to note that there are a number of programs in place. The regular unemployment insurance program provides benefits for up to 26 weeks. Most of those people who became unemployed at the onset of the shutdown are still very much in the middle of that program with 10 or 11 weeks of benefits remaining. After the unemployment insurance program comes the PEUC program, which you can see here up on the screen. That provides an additional flat 13 weeks of benefits. And then after that is a state extended benefit program, which is another up to 13 weeks of benefits. So most people who became unemployed during the pandemic would have been still in one of those programs if they were eligible. It's also important to note that I believe the guidance for P.U.A. says that you have to deduct weeks of regular UI or SEB benefits. And so the share of exhaustees that may at some point qualify for P.U.A. are probably not there yet. And if they were, they would only be eligible for a few weeks, likely toward the end of this year. The other individuals not eligible for unemployment insurance, there are additional people. If you had a bona fide job offer to start work in the state, and you weren't able to start that job as a result of the pandemic, you would qualify. That's probably a fairly small piece because of the timing between when you might have a job offer in hand and when the shutdown would have forced you to not be able to take that work. So I do think that there are some other potential pieces of eligibility, including people who have been determined to be ineligible for the regular unemployment insurance program. But the lion's share and how people have typically referred to the P.U.A. program is that it's largely for the self-employed, the gig workers, and other workers not covered by traditional unemployment insurance.
Okay, I thank you. I got most of that. Some of it I still have to process. You know, there are just so many initials and acronyms here, and if you're not in this business, it's a bit of a study here. But I understood what you said. Ms. Jones, would you like to respond to what you just heard?
Yeah, I just the Small Business Administration actually estimate there's 250,000 self-employed individuals in Nevada, not 82,000. Again, unfortunately, we know that there are issues with the census, people just not answering it. The other interesting thing that I think the analogy was used, if somebody made $1,200 a month, lost $600, they would still not be eligible for P.U.A. Well, if somebody like a gig worker was making $1,200 and is now only making $300, there's a gap. There's $181 there. That person should get that $181 plus the FPUC 600. And gig workers, it's from what we've understand from our clients, if you go down the gig worker path, D.E.T.R puts you in the gig worker path and you are unable to adjudicate any of your claims. One of the things that's been most frustrating is the state has been provided with $10.6 million to implement and administrate the pandemic and the C.A.R.E.S Act funds. And that comes from UIPL 1620. That includes notifying people of steps that they can take in their application to ensure a successful application. That also includes hiring administrative staff. One of the things Your Honor said is, he wants us to work collaboratively to come up with an order. I think that, and you also asked if D.E.T.R has looked at sister states. One of the issues in the C.A.R.E.S Act and in the Ms. Gau's declaration, the contract, if a state wants to contract with another state to help with its pandemic and C.A.R.E.S Act benefits, it can do so. So if the state has $10.6 million to administer this, to hire extra people, to train extra people, to bring back retirees, so that these claims can be adjudicated in a reasonable amount of time, that to me seems like that's another question that I hope the court will address.
Okay, thank you. Well, the reality, of course, nobody needs to even brief this. It's so well understood, and the court may take and does judicial notice that states were not set up to administer claims like this. This was a unique and event of first impression, although, some argue we should have been prepared for something like this, but that's not the point. The point is that it took a while for the state to stand up this program. I believe the plaintiffs understood that. They brought an action. Events happened. The court learned that the motion or the request for the writ was being withdrawn, and that the lawsuit was on ice for a while. And then, of course, here we are. But so the court is well aware that this is novel and new and takes time to set up and administer. The argument from the plaintiff, though, to D.E.T.R people is it's taking too long. The funds that were allocated to administer this have, as they understand it, not apparently been used or used in full to do this, that there are other avenues that could be used to work through the backlog. There could be ways to identify approaches for applicants that would eliminate or lessen those that get caught in a little bit of a limbo. I mean, that's a very broad brush I just painted with, but who can respond to some of the concerns that Ms. Jones just expressed and some of the questions that the court just set forth?
Your Honor, I'd like to take an initial response to that, if I could. This is
yes,
Robert.
Of course.
The money and stuff that Attorney Jones is referring to is with respect to hiring other people and ensuring there's a sure amount of administrative staff. D.E.T.R is not a power unto itself. It can ask for more staff. Whether or not it's going to get it, we don't know. The governor wasn't made part of this hearing today, but that's D.E.T.R can't just go out and hire people. As the court, I'm sure, knows, the state has certain statutes in place with respect to hiring individuals for state employment. I know you mentioned specifically with hiring back retirees. There's specific statutes that actually touch on those that would have to be dealt with. So it's not really, the ball's not just in D.E.T.R's court. It's not just D.E.T.R's responsibility for that.
So it's not as easy as it sounds to take this bag of 10 million plus or minus to administer and then start adding people and,
Can I comment on this?
And resources. Is that the D.E.T.R's position?
Yes, Your Honor. And again, oh, sorry, someone else was.
No, go ahead.
Administrator Kimberly Gaw can speak to those decisions in a little bit more detail.
Go ahead.
Hi, my name is Kimberly Gaw. I'm the administrator for the Employment Security Division.
Thank you. First of all, ma'am, good morning and welcome, and thank you for being here, and thank you for doing what you do.
Thank you. I wanted to talk about the three areas that were mentioned in regards to the $10.6 million, the backlog, and the hiring processes.
All right, let me say one thing though, and I didn't do this with Mr. Schmidt, and I should have. When I have people, representatives of a client, give the court information, it's going to be factual information. I generally have them under oath, so I know that they're testifying as truthfully as they possibly can. So what I'm going to do, Madam Administrator, and no disrespect intended, would you please raise your right hand, and Ms. Clerk, would you administer the oath of the witness?
Do you solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you very much. Please proceed, ma'am.
The reference dollars for $10.6 million for administration of the C.A.R.E.S Act is actually not for C.A.R.E.S Act administration. It was actually 2 tranches of dollars that was received by the department as part of the passage of the Family's First Act from Congress in order to address the expected workload increase for standard unemployment insurance with the pandemic. So the state has received those dollars. I believe the second tranche just recently came in. It was split in half. So those dollars were specifically set up to address that workload that was expected with regular UI. There was a separate allotment provided to the states, and it wasn't specifically spelled out by you get 10 million or you get this dollar amount. There were specifics in the act that indicated what we must do in order to receive administration funding for the C.A.R.E.S Act specifically. And some of those things we had to demonstrate implementation costs versus ongoing costs in order to administer the programs. The deadline to, I believe, to submit for those dollars is somewhere in September. We took the approach early on to provide an estimate and submitted a request for implementation dollars for the C.A.R.E.S Act to date, D.E.T.R has not received any dollars for administration of the CARES Act. So we have not received $1 as of, to my knowledge, as of sitting here right now, to administer either federal pandemic unemployment compensation, which is FPEC, pandemic unemployment assistance, which is P.U.A, or pandemic emergency unemployment compensation, which is P.E.U.C. We have not received any money to administer that. We're using the other dollars and the grant that we would already have received for FY20, federal fiscal year 20, in order to administer that program. So we already took the approach to do that with other funding that we already had in place. We would expect to be reimbursed by the federal government dollar for dollar based on the CARES Act information at some point, but to date we haven't received that. So that's regarding the administration funding. Regarding the hiring practices, Council Whitney is correct that D.E.T.R in and of itself cannot make unilateral decisions on how we hire or go about doing those processes. Part of the process for hiring retirees who are receiving a retirement benefit from the state, from PERS, or from a city or municipal is covered under NRS 333, or 333, excuse me. And there are provisions that require us to go through steps if somebody is within a 2-year period of their retirement. So we were aware of that when the pandemic hit, and when we started looking at retirees, there were a number of retirees that we did bring back, that we did contract with, that we went through state purchasing, and in some cases made emergency decisions to bring on specific subject matter experts to provide certain services and oversight over certain things that had specific expertise that we did not currently have in-house. Additionally, I also submitted and received approval through our governor's finance office. I requested 147 positions to augment the current staffing that we have. To date, we received approval for 133 of those to be hired, and we've hired or have a job offer in place for somebody to start within the next week or so of 108 of those positions. Additionally, I conscripted the entire department essentially to provide services for unemployment. So with the cooperation of our then director and our deputy director, Dennis Perea, who's in the South, we went through the entire department to say who has experience with unemployment, who has similar comparable experience, and we repurposed more than half of the existing staff in some form or another to either augment direct operations or provide support services. So we have done a number of different things in order to provide staffing to address. Additionally, the governor signed a waiver in May for us to add additional contract services. We did that with the Alorica call center in order to handle the pandemic unemployment calls, because we knew that volume was in excess when we first opened those lines of more than 100,000 calls. So they hired initially 100 call takers to staff up and address those calls. And additionally, they have hired 35 adjudicators to help with the adjudication process of the pandemic unemployment assistance. And that occurred the last week of, I want to say, May, and excuse me if my dates, it's all running together right now, I apologize. So those are the things we've done to address hiring and staffing to address the workload. We continue to add resources as we can find them, and we will continue to request resources of our governor's office, our governor's finance office, and the legislature as we continue on. I also wanted to address the information about the backlog of application processes. I'm aware that there in several of the briefs, in 2 of the briefs, there was also declaration information that somehow D.E.T.R did not exercise all waiver options or options to take steps to fast track the application processing. The assumptions were made that we had not done those things. And in fact, in many cases, most of those things had been done and been done very early on. So without going into details specific about every single type of thing we did, we implemented groups of teams to address specific types of issues. We, in both pandemic and traditional UI, we've addressed that with multiple teams. At one point, I think we had 6 different teams running to augment traditional adjudication and claims examiner staff. We've additionally added resources to handle just the volume of email and phone inquiries. At one point, we had over 200,000 emails requesting assistance for one or the other program that we have been fielding. So we have done all of those things and many more things that are not even outlined in the brief and some of those declarations. So that's basically a high level of those 3 areas that we're asked about.
Thank you. As to the adjudicators you mentioned, approximately how many of them have actually started working as of today, to the best of your knowledge?
The Alorica call center adjudicators, those 35 have been in place for more than a month.
Okay, thank you. Mr. Schmidt, are you still on the call? I can't see you at this point.
Yes, Your Honor.
All right, thank you. Would you raise your hand, Mr. Schmidt? You solemnly swear or affirm that the testimony you will give in this matter is the truth or the whole truth, nothing but the truth?
I do.
Thank you. Let's go back to the information you provided to the court already this morning. Do you stand by the responses you've given and the answers you've given to the court at this point?
Yes,
right.
Your Honor, I do.
All right. So we'll deem both Mr. Schmidt and the Madam Administrator's testimony have been under oath. All right. Mr. Thierman, I'll give you an opportunity, or Ms. Jones, if you'd like. Actually, let's do this. Let me back up. It's 10:40. We're going to take a 10-minute recess. I'm going to go offline. We'll come back promptly at 10:50, continue this hearing. Be in recess for about 10 minutes.
Thank you.
Thank you. Okay, Ms. Jones, let's start with you. Based on what you just heard, I mean, that, at least to the court, sounded quite encouraging at the effort being expended. Of course, that doesn't, to use a phrase, put food on the table for people that are in this purgatory of attempting to get benefits for which they believe they're duly entitled. But would you agree with the court that that was some encouraging news from the administrator of the program? Please unmute. Thank you.
Actually, Your Honor, I do not agree with the court. Respectfully, if Ms. Scott is correct, let's look at some of the numbers that have been provided by Mr. Schmidt and also by Ms. Gaw. So for Ms. Gaw particularly, she said there's about 35 adjudicators. If that is correct, and based on Mr. Schmidt's previous numbers of about 139,000 people not having been paid, if you look at a full-time equivalent job, which is 280 or 2,080 hours per year, 35 adjudicators times 2,080 per year equals 72,800 hours of work. Divide that 39,000 people into the 72,800 hours of work. It will take those 35 adjudicators 1.9 years to get to those claims. That's not encouraging at all for people that are on the verge of losing their houses because the governor's lifting the moratorium, maxed out their credit cards. I can't imagine telling my client, you have to wait another 1.9 years to have your claim adjudicated. The other interesting thing that when we were doing some calculations during the break, Mr. Schmidt indicated in his chart, and if he could bring it back up, that might be helpful to look at it again. I believe he actually said there's about 107,923 people that have been paid out of the 247,000 people that have applied.
Your Honor, would you like us to bring that up?
About 43.
Well, not just yet. Thank you. The numbers are clear in the court's head. It's less than 100. It's less than 50% of those.
Yeah. And if we look, that's the number that we should be concentrating on, not that 82,000 number. If you look at some of the other states, they're at 100%. They're at 80%. I know it's difficult. D.E.T.R's got a difficult job, but I think that they have to do better under the law, and they have to do better for Nevada. And I think that they can, and I think that you can tell them that they should, because those numbers aren't encouraging at all.
Your Honor, if I could jump in really quickly.
Yes, and again, please state your name for the record so we can, because it's hard to see you.
Thank you, Your Honor. Robert Whitney for the record.
Yes.
The witnesses up north may be able to speak better to this, but the 50% number in other states actually paying remarkably a higher percentage than what D.E.T.R's paying. Some of the information that was included in petitioner's responsive brief to the defendant's opposition, it doesn't, to be honest, it doesn't look like it appears that they're actually making the correct comparisons. It looks like when you follow the correct link, I'm not sure if what I'm trying to say, it looks like the comparison for 80 or 100% is actually unemployment insurance claims. They don't appear to be P.U.A claims. So I'm not sure if perhaps Mr. Schmidt could verify that, if that's actually correct. But so you're actually making two different comparisons here. You're making comparisons under P.U.A versus this comparison, comparing them to the amount of people being paid just under normal unemployment insurance.
Okay.
David Schmidt again, for the record, Chief Economist for D.E.T.R. I am unfamiliar with where the 80% to 100% of P.U.A claims being paid data would come from. I know that some of the data that was referenced in the response to our pleading, I'm sorry if I don't have the correct terms, was looking at Michigan with a 95% payout rate. However, those were from the middle of March. That was the payment rate for their unemployment insurance program, not for the P.U.A program, because that would have been before the P.U.A program was created on March 27th, I believe.
All right, thank you. Mr. Whitney, anything else you'd like the court to hear in response to the comments from Ms. Jones?
No, Your Honor, not at this time.
All right, let's go back to Mr. Thierman. Mr. Thierman, the takeaway from the court so far in reading from Ms. Jones' response to the administrator's data or summary of efforts that have been undertaken recently is it's not good enough. It's not good enough because processing the number of people and adjudicating and giving them a fair shake to review their applications would take an enormous amount of time, and so much harm would befall them, their family, their community, et cetera, that something needs to be done. And she suggests, as you did in your moving papers, that this court has the legal authority and should act to do it, to change the way that D.E.T.R is reviewing these, changing the way they're interpreting the law, changing the way that they are processing these. As we saw from the writ that brought the parties in front of the court today, there were three separate deadlines or date points that the petitioners are asking the court to direct payment to have been made at the earliest of the three. That's one way to move these people through the system and get them money that you believe they're due. Do I have that right so far? And Mr. Thierman, go ahead and unmute your microphone, please.
Yes, you're correct, Your Honor.
All right, so that's one way. That's one way to move through the backlog. The question is, does doing so violate any state law, federal law, agreement between Nevada and the federal government, inconsistent with good practice, common sense, or something else? What do you think?
Would say not, Your Honor, and I would tell you the reason why is because whenever we have, again, what D.E.T.R refuses to accept is that this is a property right, that it belongs to the claimant. At some point, it belongs to the claimant. What we have is thousands of people saying they have no, there's a whole procedure that D.E.T.R is supposed to do, due process procedure. It starts at question number 13 on I-11 of the attachment 1 to the 1620. And it says they're supposed to give them notice individually what's wrong, how to fix it, et cetera, in a timely manner. They're not doing that. So as I mean, I may be dating myself, but Kelly v. Goldberg happened when I was, when I was in law school. What the default is, you pay these people because you, D.E.T.R, can't provide an administrative mechanism for giving them due process and notice that claim, when made, unless it's totally on its face focus, should vest the property right unless it's challenged. What D.E.T.R does.
But hold on, you saw the state's response to that argument, and they said if we do that, we Nevada run the risk of having to disgorge the funds from the federal government back to Washington, D.C., and that would put Nevada in financial peril worse than what we're looking at now.
Completely, Your Honor, because the regulations say that they're supposed to provide due process. The Supreme Court says they're supposed to provide due process. They can't issue these. I mean, for all 139,000, I would ask the administrator, how many have actually been made a determination, and how long have they been sitting there? Because after 4 weeks, I mean, they're supposed to make a determination in 2. After 4 weeks, why isn't it a default? And again, we're using the face of the application to spot obviously non-compliant or things that are totally out of the ordinary. But why are we going further than that? There's no reason. Everything is a self-attestification. Everything is, and if the claimant believes it, and D.E.T.R has no reason to suspect it, there's no reason in the regulations to go further. And that's exactly what's happening. They're going further, or they're doing something to delay these claims. Because the only reason, there's no reason to be holding these things up if it's not on the face of the application. And if it's on the face of the application, why does it take so long to make a determination? Or why are these people being told, oh, there's nothing wrong, but then they're being told, well, there are issues. But then all the eligibility requirements have gone. Now, in her last declaration, the administrator admits that they've been sending these letters for eligibility out, saying people are eligible and not paying them because they didn't hit the button. I would suggest that everybody who's more than 4 weeks old should get the button hit. Everybody who has had a determination at any time in their favor should have that button hit. And that I base on JAVA. They cannot retroactively re-examine the application once they've accepted it. And that's what they're doing. They're saying, oh, well, you're approved, but at any time later on, we can disapprove you retroactively. That's not what JAVA says you can do. So I would say that is the other kick, or the other bundle of people to get them through quickly. And finally, I can't imagine that if they're not getting paid under the UI program, I have no problem with duplicate checks. I mean, we're not allowing double payments, and that they can check by simple social security numbers at the time of payment. But if they have a disability, they have a reason why they're not getting paid UI, but they're eligible for UI, let's waive that disability. And one way that's already in the statute of waiving or forgiving that disability is having 16 weeks of income, which I'm sure most of the gig workers have, is 16 weeks of prior income before their claim, so that they could say, yeah, I have 16 weeks, so I've made up any penalty. The way I understand it works is this. If you have a disability, if you quit your job, they say, oh, you can't get unemployment until you have so many weeks of earnings so that you're back in good graces. 16 is the maximum. Why not just say, okay, everyone's 16 weeks of because if they have 16 weeks of self-employment income prior to their application, then anything that's disabling under the old UI system is forgiven. And if they are covered under the old UI system, they should be getting payment from that. So the whole mechanism for reclaiming this is to take away from the to ask for repayment by the claimant if you've overpaid. That's the only mechanism, actually.
Well, we all know how that's going to likely go.
But if they're owed the money under UI and haven't been paid it under UI, then you have a claim against the UI. So the P.U.A. has a claim through the applicant against the UI. That's what I'm saying. You do have you have a deep pocket there. It's yourself.
Okay. Who would like to respond to what you just heard from Mr. Thierman and Ms. Jones about the concerns that they've raised and as expressed in the briefs? Who would like to further argue to the court on that?
Your Honor, I'd like to take a stab.
Go ahead.
Try at that. Thank you. This is Robert Whitney for the record. What counsel says, the property right in the Java case, property right to the benefits here, you don't have a property right. You're not entitled to those benefits until a determination has actually been made. In many of these cases, a determination hasn't been actually made yet. The person's eligible for those benefits. Counsel cited some of the letters, and I agree they are. D.E.T.R also agrees they are problematic, but you really have to read those letters. Some of those letters just say you're financially eligible. You've been found financially eligible, but this doesn't mean that you're entitled to your full benefits in substance. And some of them, frankly, are confusing. But again, the person's wasn't found. There wasn't a benefit determination that had actually been made where they been found eligible for benefits or not eligible for benefits. So there's no property right that's attached.
I want to make sure we're all clear, because we're all aware that many people are observing this hearing and are interested in the outcome. And so for their benefit, as well as those of us on this call, when we say property right, it's not like a piece of property like a barn or a house or a building. It's a federally recognized, protected right to something. In this case, the allegation by the petitioners is to unemployment benefits. The jurisprudence, the body of law that supports that argument exists, but whether it's a bit nuanced, whether it's distinguishable, whether it applies to these facts, this case at this time, is something the court is still wrestling with. But we're talking about the legal right, a protected federal right to unemployment benefits. And then when does that right accrue? When does it start? Does it start when you hit the application? Does it start when you have received benefits and they're pulled away? Does it start when you receive benefits and it's later determined that you should not have received them? When does your federally protected right begin? And the answer to that is to be determined. That's something the court is being asked to review, consider, and make a decision on today. So for the benefit of everyone, that's what we're talking about. So please continue.
Thank you, Your Honor. And with respect to what Mr. Thierman said about the 2 weeks deadline in oral argument, also there's mention of 2 weeks after April the 1st. Again, that seems to, in large part, be based on the 20 CFR 640.4 and 640.5.
Let me stop you. Let me tell you why. If a writ is going to be issued, it's likely not going to involve an order that says somebody who's been eligible 2 weeks after July 11th, if that's the earliest of the date. The other two seem to have more appeal to the court with respect to whether there was a prima facie valid application for benefits presented to D.E.T.R. That's what Mr. Thierman, I wouldn't call that his bell cow, but it seems like he's been emphasizing that both in his brief and in argument to the court that if on the body, the four corners of the electronic document, if it looks facially valid, prima facie valid, then benefits should start. Or secondly, which is what brings us here as well, is whether the first letter of unemployment qualification determination approved or temporarily approved or preliminarily approved benefits, even if later it was subsequently determined that the benefits ought not to have been paid. Those are the two that are right now seem to be resonating a little bit more forcefully with the court than the 2 weeks after April 11th date. So you needn't spend too much time on that.
Thank you, Your Honor.
You're welcome.
With respect to the valid application,
yes,
Your Honor, according to the federal law, D.E.T.R has to determine whether or not the person is actually eligible. For example, under P.U.A, they have to determine first whether, and I think Mr. Smith touched on this, is the person eligible for unemployment insurance? Is the person eligible for extended benefits under state law, under federal law?
When do they have to make that determination? We just heard that if we believe Ms. Jones' math, and if we believe that the adjudicators, and I think, there probably were adjudicators before, the administrator just seemed to advise the court that additional ones have been hired. But you have to agree, would you not, that it's going to take an awfully long time in the middle of an economic crisis, unlike any that's befallen this state, for such determinations have been made with the level of detail that ordinarily occurs. Wouldn't you agree with that?
Your Honor, this is Robert Whitney. I would say yes, that you are correct. It appears that it's going to take some time, but you'd ask is, is there really a set timeline? No, there's not. None that I'm aware of. Recall, and we put this in our argument, that when due, it's kind of a balance. You want to ensure the payments are made fairly quickly, but on the other hand, you want to ensure accuracy, to ensure that not only is there not fraud taking place, but that there's not payment made to somebody that shouldn't get one, where there's just not fraud in place. Maybe there was a mistake the person had made in filling out their application. The large sum of people too that still remain to be paid, that's just, in a sense, with what we put in our application dealing with fraud, it may not be best to assume most of those people are actually eligible for payment. Again, if somebody has committed fraud, if there's an application that D.E.T.R believes is fraudulent, that's not going to get paid. And D.E.T.R's presented quite a bit of evidence that there is quite a bit of fraud taking place.
Well, listen, I mean, I'm not naive enough to think that let me put this delicately. When people apply for benefits, state benefits, federal benefits, there's always a level of people that are not noble, that are dishonest, that are trying to game or cheat the system. And that's probably no different than what's happening in Nevada and other states that are dealing with the pandemic-related employment and economic harm. But that alone, the concern there, is not going to delay this program from being administered and people to be paid. It can't, because the exception would swallow the whole genesis of this law and the remarkable level of benefits made available by the federal government through the states to people in need. So is some of it happening? Of course. Is it happening more now than you would ordinarily expect? Debatable. Is that going to slow down the train so we can handle that concern? Probably not, with all due respect. I just am concerned that people are suffering while claims are being processed. Mr. Whitney, I don't know how else I can better say it. I'm looking for a way to balance. I think that's the word you used. Find the right balance here between paying claims to deserving people as promptly as we can and make sure there's no abject or irretrievable harm done to the program itself by virtue of paying claims that are not worthy. Give me something. Give me something other than, you know, we're working as fast as we can.
Your Honor, Administrator Guy, I think, can provide some information about how she's balancing those concerns, if you will.
Okay, I'd enjoy hearing from her again. Madam Administrator.
Thank you, Your Honor. In regard to the process, there's two different situations that I think are getting conflated a little bit here. Is the difference between standard unemployment and pandemic unemployment. As counsel for the petitioners indicated, that there is a disqualification period and a requalification period, and those are not applicable to P.U.A. So I want to make sure we're differentiating between the two programs because they're not one and the same thing. Although they are similar in the resulting outcome for benefits for Nevadans, the process is slightly different. Specifically with UI, I want to be very, very clear that Nevada has taken extraordinary steps to automate every process available to it in order to make decisions on claims as quickly as possible in regular UI and in pandemic unemployment assistance. It's important to note that Nevada has not had to administer a similar disaster unemployment assistance program in its system in more than 20 years. We only could find one employee in the department after asking around who had any experience with working with the disaster unemployment assistance when this hit. So we're talking about two very different paths here. Specifically with regard to the numbers that Ms. Jones was citing as far as how long it would take to adjudicate, not every claim has to be adjudicated to that extent. So it depends on the information provided by the particular filer. It depends on if there's indicators to suggest that that person may be eligible for another benefit and or standard unemployment or one of the extended benefits. It depends on if some of the flags or factors that's being shared with by law enforcement and other states with us indicate that those claims may be fraud. It may indicate that it's not even a human that filed that claim, for example. So there are a plethora of reasons why we look at the claims, and how long it takes for us to look at an individual claim could mean a matter of minutes versus a matter of hours. So to say unilaterally that it would take 2,088 hours divided by the number of claims and come up with it would take a year and a half, it's probably not a fair depiction of the process. If that were true, we wouldn't be paying 107,000 claimants benefits right now, because we'd still be working through those claims in order to pay them. So I think there's an issue with that level of understanding. There also seems to be some confusion about the interpretation of when it's due. The standing interpretation by both Nevada and many other states, and I would argue that the Department of Labor would look at it this way and has audited us as such, is that when due is when determined eligible. So it requires us to make a determination. Excuse me, I apologize, I'm losing my voice today. It requires us to take every step required in order to make that eligibility determination. And we would pay when something was determined eligible, and we would not pay when something is not eligible. So a number of those 147,000 claims that still remain, not all of those have been determined not eligible. Some of those may be in that eligible category. However, we know that a large number of those probably are not. With regard to fraud, I understand that that in and of itself shouldn't delay. But we have to do our due diligence to make sure we can determine whether or not something that is flagged for fraud is appropriately fraud, or if this is a legitimate claimant. And we do hear from legitimate claimants that have had their identity stolen, for example, and we have to work through the process in order to reestablish a proper claim for them and address the other claim that was filed improperly. So these are existing issues that we face, that we have staff actively working on throughout the department. And to your Honor's point, that is correct. When I was providing those numbers on hiring, I was specifically referring to the augmentation post-pandemic.
All right, that's what I understood. Thank you. Go ahead, Mr. Whitney.
Thank you, Your Honor. If I could have Mr. Dennis Perea sworn in, he would like to add something also, Deputy Director Perea.
Oh, excuse me 1 second. I lost that. Would you repeat that, please?
Thank you. If we could please have Deputy Director Perea sworn in. He has information that might be useful to the court on this.
Okay, if you could, since I can't really tell where you are, would you mind standing up? Thank you. Would you raise your right hand? I'll administer, Ms. Clerk. Do you swear or affirm the testimony you will give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. You may have a seat. What would you like to inform the court about?
It's your question about, it sounded to me, Your Honor, like you're saying, what is the plan? And I just wanted to address Counsel Jones's comments about 1.9 years. The straight line math equates, but the reality is that the 35 we added to the Lorica contract is not enough, and we're bringing more in. And the other part of this is human intervention in itself is not going to clear this backlog. It's going to continue to look at these groups and make educated decisions on how to use our IT lists to actually clear out the fraud out of that system. So if everything was held constant, sure, we could get out a long time because that backlog is huge. But the fix is adding resources. Currently on the P.U.A, on the funding portion of that, we haven't even been given a mechanism to draw down from the federal government on that yet. So we're actually working with the state to figure out how to get the cash set aside as a treasury function to bridge the gap to when the feds finally give us the chance to bill against that so that we could bring in more resources on the P.U.A side. But to be quite frank, if we brought in 100 tomorrow, it takes time to train. It takes time to do that. So it's going to be a combination of adding additional resources, coming up with IT fixes and whatnot to clear out the fraud that we know that's in that system, and continue to add resources and train until we can break that backlog. But to just release the fraud, I think, is just impractical, and it would be disastrous, kind of like what happened in Washington.
Thank you. Well, we're coming to the end of our journey here. Mr. Thierman, I'm going to give you a chance to summarize your ask, why you believe the court should grant the request. Then I'll hear from the state, and then the court will share its comments, thoughts, and decision. Mr. Thierman.
Thank you, Your Honor. My ask is that as many groups as possible of the gig workers be automatically or immediately issued payment for all amounts that they've already been determined that they would have gotten if they weren't held up in the system. I think that this whole adjudication and time issue seems problematic in an age where we have computers and it's a check sheet, and the DOL's own guidance says, except for the number of hours that you have under the old UI, and that's just the number of hours in the last 18 months, everything else can be done by self-certification. And unless there's some specific reason that the application is in doubt, whether it's a foreign IP address or whatever, pull those out. We will reduce the number of pending applications from 139,000, to maybe 10,000 or 5,000. I mean, I'm looking for systemic solutions. I don't want to even to think that we have to adjudicate 139, fair hearings. It'll cost us more than the benefits. I don't think that the system's set up for that. I also think that all the indications, all the instructions say the state's supposed to use flexibility to pay, because the purpose of this thing is to pay, and we cannot have the baby thrown out with the bathwater because there may be a $5 million or $10 million fraud on $1 billion worth of assistance. The groups that I have identified would be those who would be determined eligible by D.E.T.R in one form or another. And usually it's a letter, and it says an eligibility letter. If those people have issued a letter, then they fall right in Java, and there's nothing in the Secretary of Department of Labor's regs that would contradict that. In fact, their process requires it, that once people are entitled to benefits, they get a hearing before they're taken away. And by the way, I'll just add, and I know Mr. Ganasso is familiar with the apprenticeship issue. When the state loses its apprenticeship certification, which did not happen in Nevada, but has happened in other places, the feds assume it. That's exactly what would happen here. If the state doesn't pay these benefits, if we lose the right to administer it, the federal government will administer it. The benefits aren't going away. It's the bureaucracy that goes away. So I don't think the threat of woe is me, and nobody's ever been decertified by the feds in all the history. And it's all about good faith and trying the best. And that's all the federal government really can expect. And nobody called up Eugene Seclear and said, hey, Eugene, we have a problem here. Let's fix it. He's the Secretary of Labor. He used to be a labor lawyer at Gibson Dunn and other places. Anyway, we're stuck because everybody's taking too long to make a simple decision. Is the face of the complaint, is the face of the application, combined with the one computer check of the number of hours in the old system, support a claim. And if it doesn't support a claim because they're due UI, then pay the UI. Now, so my first group to carve out would be those who have determination of eligibility. My second group would be anybody who's got 16 weeks of self-employment before claiming. I didn't quite understand why a disability wouldn't carry over. My understanding, if you're not eligible for UI, except for these disability issues, these behavioral issues, if nothing else you want to call them, you quit your job or you were fired for cause or whatever, you get the P.U.A. So what's the problem? If you got 16 weeks of self-employment, you've already cut out the disability issue. It's either UI or P.U.A., one or the other. And like I said, you can go back and get through the claimant and reclaim it, because if he's not owed UI, then P.U.A. should have been paying him. If he is owed the UI and P.U.I. paid him by mistake, then fine. P.U.A. has a claim against the claimant, his UI payments that are being held up. And finally, I know you don't like this, the 28 days in limbo. It doesn't take a long time to make this prima facie showing of eligibility. Those decisions should be instantaneously. It shouldn't be done by people. You should add up the boxes. There should be some scores or whatever, and some self-certification, self-attestation. We allow electronic signatures in Nevada. We allow, and by the way, those same systems also verify identity. But why not have a time limit? Otherwise, there's no consequence to it. If you look at the states we have 44% of the gig workers not being paid. 40%, they say. It's getting better. Now we're up to 38. At this rate, we'll be 2 years down the road before we get 100%. And they say, well, I mean, and not one of them has received a determination of denial. So where do they begin the process? Where do they start? How are they supposed to know how to fix it? All they get told is, oh, everything's okay. And then their record says, oh, there's a problem. Oh, no, it's not a problem, but we're not paying you anyway. I think the system has got to be done in groups. The 3 groups I suggested are those 3, and that would take care of 80 or 90% of everybody else. And then we can worry about the 10% that fall through the cracks. But I think everybody who's applied, if they make a prima facie showing, unless there's some other external indication of fraud specific to that application, let us start the payment immediately. And that's what payment when due means. It's when due, not when you can do it. It's when due. And due is a physical existing fact, not a, oh, when I decide it's due. Then what's due means nothing, when due means nothing.
Thank you. I understand petitioner's argument. Well stated. Who would like to summarize for the state of Nevada?
Your Honor.
Mr. Whitney summarized. I just wanted to state one thing because Mr. Thierman has said a couple times that self-attestation is enough and that should be the end of the story. And that's directly contrary to UPL 1620 change 1. It's on page I6, subsection D. It says, is self-attestation sufficient to determine that an individual is not eligible for regular UC, EB, or PEUC? And the answer is self-attestation is not sufficient to demonstrate ineligibility for regular UC, EB, or PEUC. So that's the argument that self-attestation itself is sufficient is directly contradicted by Department of Labor guidance. So I just wanted to put that on the record before Mr. Whitney addresses the rest of the claims.
All right, Ms. Clerk, do you have the name of who was just speaking?
Sorry, that was Greg Ott.
Thank you, sir. Mr. Whitney.
Thank you, Your Honor. I'll try and be brief. What petitioner is asking for here, again, we shouldn't lose sight of it, is for writ of mandamus. There has to be a clear present duty for D.E.T.R to do something in this case. In this case, to frankly pay P.U.A. FPUC benefits before an eligibility determination is made. There's nothing in the UPL guidance, there's nothing in the C.A.R.E.S. There's nothing, again, we've argued that the C.F.R. doesn't apply, that says D.E.T.R has to take all applications on their face and process those within a 2-week period, within a 4-week period. As Mr. Ott just said, again, self-certification, UPL 1620, change 1, self-attestation isn't enough to determine ineligibility in the context of the P.U.A. for unemployment compensation, for extended benefits, or for the pandemic emergency unemployment compensation. But again, there's nothing saying that D.E.T.R has a clear duty to just take all applications and process those within a certain amount of time period. It sounds like from what Administrator God did, they're actually, many of those applications are proceeding without error, but then there are some that are flagged. Specifically with respect to P.U.A., we've heard petitioners talk about, and also they argued it in their brief, they talk about the verification really and steps for verifying what's needed there. Petitioners at times called it an investigation, but again, there's no definition of what verification is. There's nothing saying that D.E.T.R is doing something wrong. It has a clear present duty to do something else.
Okay.
As far as again, just really briefly, the dates, the specific dates of April, those as far as D.E.T.R can tell, those don't appear to really be anchored in anything solid, because again, we've argued that the CFRs, 20 CFR 640.4 and 640.5, they're inapplicable here. You're talking about state unemployment benefits with those regulations. It's also my understanding from talking with David Smith that the federal government doesn't even, the reports that are used to report the information required by 20 CFR 640.5, that time difference between when the unemployments are paid out and when an eligibility determination is made, that the Department of Labor doesn't require reports that information with respect to P.U.A. payments. Those are payments made for unemployment insurance. And finally, again, with respect to the letter that's been issued, the letters that have been issued, D.E.T.R recognizes there were some errors in those letters, and maybe some of them probably should have been worded better. But it's also clear with those letters that you don't have an eligibility determination for benefits. You may, I think the one we saw, the most examples of was financial eligibility determination. For those letters, at any rate, it's clear that you're not dealing with that you're not being told that you're getting full unemployment benefits. So I think the bottom line here, Your Honor, is a writ's not appropriate to order D.E.T.R to take the actions that the petitioner is asking for. Thank you.
Thank you. Also well stated.
Thank you.
All right, give me just a moment here. I have to give further thought to the approach the court intends to take here. Let me mention something that just occurred to me. Mr. Schmidt, when this hearing is over, would you please address the two exhibits that you shared during the full screen, one to the court clerk, Ms. DeGaynor, and of course to plaintiff's counsel. They will be part of the record of this hearing.
I will, Your Honor.
Thank you. Here's the court's decision. The petitioners have requested the court to issue a writ of mandate or a writ of mandamus to the state of Nevada, specifically to D.E.T.R, to order it to do something different than it is currently doing. The law in Nevada generally states that such extraordinary relief is to be exercised by the court when it is convinced that the party against whom the writ is brought is abusing its discretion or exercising its acts in an arbitrary and capricious manner. It is the petitioner's burden to demonstrate that the court should issue the writ of mandamus. If they haven't met that burden, the writ does not issue. If it's a toss-up, the writ does not issue. They have to show more evidence, more authority, more argument, more persuasiveness than that opposing in order for the court to issue the writ, to order another branch of government to do something differently. A court, in reviewing the evidence, considering the law, listening to the arguments, considering the evidence, has discretion whether or not to issue such a writ. The court has fully reviewed all the briefing. The attachments to the briefing, and now heard some excellent presentation of each side's view, and learned a lot more than the court knew this when we first started this hearing. Is the court convinced that a writ should issue? Not quite. Almost. But not quite yet. So here's what we're going to do. In the court's tool belt, the court has authority pursuant to Rule 24 of the Second Judicial Court rules and Rule 53 of the Nevada Rules of Civil Procedure to appoint a special master to assist the court in better understanding facts, identifying issues, assisting the court in gaps of knowledge and information that the court on its own would have a difficult time identifying and understanding. The court appoints Jason Guisson of the Hutchison and Steffen firm as a special master in this case. We'll talk in a moment about what exactly he's to do and the accessibility that I'm directing the parties to give to him and cooperation. But let's talk logistics. Tomorrow, that being Wednesday the 8th, at 2 o'clock Pacific time, the court directs a short hearing with the master, Mr. Guisson, and counsel for each side to go over the charge that the court is giving to Mr. Guisson and the best way to assist him in accomplishing that. That doesn't mean that I'm not asking Mr. Guisson to begin meeting with and discussing with each side later today, if his time allows, on how to start moving the process forward. But we're going to formalize exactly what he's going to do and when the court expects him, with his input, of course, him to be able to do it at 2 o'clock tomorrow. So unless counsel has an immovable conflict, we'll send you another link to a Zoom webinar, and we will meet at 2 o'clock and go over Mr. Guisson's charge. Second, I'm going to ask Mr. Guisson to do what the court is asking him to do within a week, and then file a report of his findings. Now, if we're not formalizing this until tomorrow, well, I can't ask him to completely move a mountain in short order, but I would like a report by him no later than 1 week from tomorrow at 2 o'clock. So that would be the 15th at 2 o'clock, with a hearing on Thursday, the 16th of July at 9 a.m., at which time the court either will grant a writ or deny it. And then the case, goes forward from that point. But the court does not contemplate any additional time lag other than this 8 or 9 day time period the court is directing to gather more information. So report to be filed by Wednesday the 15th, 2 p.m., Mr. Guisson. If we can manage that, we'll talk more detail tomorrow at 2. Hearing Thursday the 16th at 9 a.m. to discuss Mr. Guisson's findings and recommendations, which the court will then utilize to make a final determination whether a writ should issue, and if so, in what form. A little more information with respect to the master. Rule 24 that I indicated of Nevada 2nd Judicial District Court local rules, subpart 2 indicates the court may refer any matter for determination to a master on the court's own initiative. That's what's happening here. NRCP 53, subsection A2B, indicates that a master may be appointed to address pretrial matters that cannot be effectively and timely addressed by the court, including those designed to save expense and needless delay. Under Rule 53B4A, Mr. Guisson, the law requires that you file an affidavit, in this case indicating that there are no grounds for disqualification of you or inability to serve under Rule 2.11 of Nevada's Code of Judicial Conduct. So please review that rule and make sure there is nothing personally or professionally that would preclude you from serving as a special master in this case. Tomorrow, the court anticipates at 2 o'clock identifying the duration of Mr. Guison's service, will confirm that ex parte communication with each side will be allowed. We'll discuss further the type of work he will be asked to do and what his report should touch on. The court anticipates that Mr. Guison's expense, professional service expense, will be shared equally by the parties. The court has authority to make that decision pursuant to Rule 53G1A, although that preliminary determination by the court right now is not final. It's subject to being reviewed and considered. And in greater detail tomorrow at 2 o'clock, it'll be a discussion about what the court wants Mr. Guisson to do. But look, here's the gist of it. I want Mr. Guisson to do a complete inventory of how claims are processed from the time they first show up online to the point in time that a determination of benefits is made and extended or not. I want to know what goes through that algorithm. I want to know where the bottlenecks occur. We've heard discussion of that today, and I'm certainly much more informed than I was before I took the bench this morning, but I want more information. Where are the bottlenecks? Where are the inefficiencies that can be addressed? What particular decision does this court need to make with respect to how these bottlenecks can be lessened or completely eliminated? How user-friendly is the website? How can changes be made to eliminate duplicity, to eliminate human error, to eliminate confusion? How can communication with applicants be improved so that they know the status of their claim, what is expected of them, and how they can accomplish what is being asked? Things like that. That's not an exhaustive list. That's a primer for our further discussion tomorrow at 2 o'clock. Now, let's be clear. It's the court's job to interpret the law and make decisions consistent with the law. The court needs additional information and facts. That's what Mr. Guison's job, working with each side. I want to know how many claims have been paid, of how many submitted. I have a general understanding of that as of this morning, but I'd like it freshened and updated by the time of the report. I'd like to know how many of them the D.E.T.R believes are fraudulent on their face, computer generated on their face, people outside the country, people with invalid social security numbers, any indicia that people are not being straight with the state of Nevada. They don't deserve benefits if that's the case. But let's, again, I want the court to be clear. The current status is unacceptable to the court. You know, in normal times, good is to be applauded and great is to be rewarded. But these are anything but normal times. People are suffering and families are hurting. Now, I'm not making any comment on the efforts of D.E.T.R, their staff, their administration, to the effect that they are not performing their duties diligently. In fact, I'm convinced as I sit here, it's anything but. That they're working their level best to get through the crushing backlog of claims in these extraordinary circumstances. But I don't want good. I don't want great. I want heroic. That's what the court's expecting. I'm very encouraged by the efforts that D.E.T.R has made and is making. And I am heartened by the presentation of the senior staff and their counsel to explain to the court their view of the law, their efforts that they are undertaking, and their genuine concern with the people that make application. Having said that, the status quo right now is unacceptable. So Mr. Guisson is going to help the court understand better where the delay is primarily involved. And if the court believes the law requires further action by the court to relieve that, consistent with statutes and the enabling legislation here, the court will not hesitate to issue a writ of mandate at our hearing next Thursday. So that will be the order of the court today. 2 o'clock tomorrow. Mr. Guisson, you can unmute. Is there anything I've said with respect to the timing or your ability to assist the court that gives you pause or you have any concern about?
No, Your Honor, this will be my #1 priority. I've cleared my calendar and will adjust my schedule in accordance with what the court is directed.
Thank you very much. Mr. Thierman or Ms. Jones, starting with Mr. Thierman.
I'm available and I'm hopeful that we'll get a result quickly.
Very good. Ms. Jones.
That sounds spectacular, Your Honor.
Thank you. Mr. Whitney or anyone else from the state like to address the court?
Your Honor, I'm sorry, Your Honor. This is Robert Whitney. I should be available tomorrow at 2 p.m.
Perfect. And listen, I just want to explain something. You know, no one's being punished by the fact that a special master is being appointed here. This is designed to help you, help me understand and rule on this very important case. But I know that people are interested in a decision, and one will be rendered on Thursday of next week based on the information from Mr. Guisson, plus anything else that's been updated as of next week. So until 2 o'clock tomorrow, the court will be in recess. Thank you very much, everybody. I wish you a pleasant afternoon.
Your Honor, may I ask one clarifying question?
Yes, of course.
I apologize for my ignorance in this matter in dealing with this process, but you had mentioned that he may be reaching out as early as this afternoon. I think this goes without saying, but is it safe to say that he's bound by confidentiality and that we're free to show him what we're doing on the fraud front and that won't be disclosed to the public? So
here, that's a good question. So I want Mr. Guisson to have access to each side to understand what you're doing and how you're doing it, unless until directed by the court to identify information that's imparted to him in confidence, he's not to do so. But I want you to assume that the data that you deliver, the processes that you will identify, that might be fair game. So, you know, don't tell him anything that you think would otherwise be privileged. But under these circumstances, I want as much direct data and information as to how the state is going about its business as I can possibly get. So how's that for a muddled answer?
I appreciate it, Your Honor. We just want to make sure we're not giving bad folks out in the community the keys to the kingdom, but we are more than happy to share that information.
Well, we don't want to give Guisson keys to any kingdom, I can assure you that. But levity aside, if you tell him that this is proprietary, it's intellectual property, it's not to be disclosed under state or federal law, then he won't disclose it. On the other hand, if you tell him how many people have applied, how many people have been accepted. Again, these are numbers like the ones we looked at earlier today that are being updated and explained further. That information will be part of his report and subject to the court's review and consideration.
Thank you, Your Honor. And if I may, as you pointed out, there's a lot of people watching this hearing, and I want to say we do care.
You know what? The court understands and appreciates that, and that's the way the court viewed the responsibility of those running D.E.T.R. All right, so Mr. Guinasso, you don't have to wait till 2 o'clock tomorrow to start talking to people here, but do review 2.11 and file the affidavit, please, in this case. One more thing I just remembered. Among the court's other duties, I am the judge in Washoe County that oversees the mandatory arbitration program on certain claims, and I have the right to exempt matters from that program on motion or sua sponte, and I do it on my own accord here. This matter is exempted from the arbitration program. All right. Thank you very much, everyone. Until 2 o'clock tomorrow, the court will be in recess. Thank you.
Thank you.